Charter.
We are, Your Honor.
All right, I'll hear your opening statement, Mr. Fenn.
Did you want us to use the microphones or?
Yes, I would like you to use some microphones, please. Or you can come up to the podium and use that.
Use
if
this one?
that's easier.
Okay. Above the law. No one is above the law. No one. Not law enforcement, not him. The evidence will show that on May 5th of 2018, at approximately 4:45 p.m., in the city of Rochester, county of Monroe, state of New York, the defendant, Michael Sipple, assaulted Christopher Pate. In that the defendant took Christopher Pate to the ground, he punched Christopher Pate about the face and the head, and then he tased Christopher Pate in the lower back while he laid on the ground. These actions were intentional, and they caused Mr. Pate to suffer lacerations to his face and his head, a fractured orbital bone in his face, and puncture wounds to his lower back, and substantial pain. You're going to hear witness testimony. You will see photographs from that day. But we have more to show you.
Excuse me, counsel, I'm the fact finder. We have allowed cameras in the courtroom, but I'm the one that you're talking to right now.
Yes, Your Honor.
Thank you.
We will have video and audio from that day, and the video speaks for itself. It shows you what happened. You can see with your own eyes what the defendant saw, what he said, and what he did that day. And you can also see how the victim looked and acted that day. You will learn on May 5th of 2018 that Michael Sipple was a Rochester police officer, and he was on duty at the time he committed this crime. The people of the city of Rochester entrusted Michael Sipple with an enormous amount of power when he was sworn in as a Rochester police officer in 2009. Our society has rules, and Michael Sipple was entrusted to enforce those rules. However, those rules apply to Michael Sipple just as those rules apply to all citizens of our county and our city. You will see that after watching the video, Michael Sipple abused the very power that the people of the city of Rochester entrusted him with. You will see that Michael Sipple had no reason to stop Christopher Pate. You will see that Michael Sipple had no reason to put his hands on Christopher Pate, that Michael Sipple had no reason to punch Christopher Pate, that Michael Sipple had no reason to tase Christopher Pate, and Michael Sipple had no reason to arrest Christopher Pate. You will see that that nothing Michael Sipple did that day was reasonable. Nothing was justified. Christopher Pate did nothing wrong that day. He was just walking to Rock Recovery to volunteer. You'll see that Mr. Pate was just walking, wanting to be left alone. Mr. Pate did not violate any laws on May 5th of 2018. Christopher Pate will tell you about his injuries, the fractured bone in his face, and the subsequent surgeries that he has required to reconstruct his face. He'll also tell you about the lacerations he suffered and the wound to his lower back. And he's going to tell you about the pain he suffered on May 5th of 2018 and the pain he continues to suffer even today. Although police are allowed to use reasonable force in certain circumstances, in certain situations, there was nothing reasonable here in this situation. You will see that this was a situation in which the defendant, Michael Sipple, began and ended himself. The evidence will show that the defendant was the initial aggressor, and there was no justification for any arrest.
Excuse me, I'm
Sorry.
sorry. Deputy, could you tell whoever's talking that loud in the hall that they're to stop now? My apologies.
as we were saying, that there was no justification for any arrest. And at the conclusion of our evidence, I will ask you to hold Michael Sipple accountable for his actions that day and find him guilty of assault in the 3rd degree. Thank you.
Thank you. Mr. General Minister, do you wish to make a motion?
I do, Your Honor. First, I'd like to thank the court for its attention. I know you would say, well, it's my job and I'm just doing my job, but I wish to thank you for the amount of time and effort that you've put into this case thus far, and in your words, to engage the mechanism. I know what you know what that means. The proof will show on May 5th that Rochester Police Officer Michael Sipple was assigned to a proactive or a special detail to locate wanted suspects. Rochester Police Department has a wanted board. You'll have an opportunity to view that board and the individuals on it and the individuals that Officer Sipple and Officer McAvoy were specifically looking for on this particular day. You'll learn what a felony package is, and you'll learn that in this specific case, James Barrett was on that wanted board. He was a wanted person for a felony for burglary and criminal contempt. You'll see the photos that Officer Sipple viewed prior to May 5th and on May 5th. You'll see and you'll make the determination as to the similarity, physical similarity between Mr. Barrett and Mr. Pate in this case. On May 5th, Officer Sipple was assigned with an Officer Spencer McAvoy. Officer Sipple was driving an unmarked vehicle. Officer McAvoy was in the passenger seat. Both were in full standard uniforms that we're used to seeing. It was during this time that Officer McAvoy alerted and told Officer Sipple, "There's James Barrett." At this point, we believe that the proof will show that at this stage that there existed at least reasonable suspicion, if not probable cause, for Officer Sipple to approach who he thought was James Barrett. Officer Sipple's observations of the initial interaction between Officer McAvoy and the proof will show only reinforced his belief that the individual that they were encountering that day was reasonable to believe was James Barrett. You'll hear evidence that upon exiting the police vehicle, upon Officer McAvoy exiting, that the individual who they thought was James Barrett immediately crossed the street in front of another vehicle, impeding that vehicle's progress. You'll see that the observations made by Officer Sipple only reinforced his belief that the individual they were encountering that day was in fact James Barrett. You'll hear testimony, I anticipate you'll hear testimony, that based on his training and his observations, his belief that this individual was James Barrett was reinforced by this individual's clothing, the particular backpack and manner in which it was being carried, this individual's demeanor, and this individual keeping his hands from plain view. I think the proof will show that while a citizen has the right to walk away from police, they also have an obligation and perhaps a responsibility to cooperate with a police investigation, an ongoing investigation. Despite what we believe the proof will show Officer Sipple having a DeBoer level 3 or 4, he tries to avoid use of force, and he requests identification. The inquiry by Officer Sipple, and the proof will show, was met by this individual with, "I don't have to show you shit." Further reinforcing Officer Sipple's reasonable belief that this individual that he was dealing with on May 5th was in fact James Barrett. I believe that the proof will be clear that Officer Sipple's intent, his conscious aim or objective on May 5th, was to detain and arrest the individual that he reasonably believed was James Barrett. That he wasn't trying to avoid any physical altercation with this individual, and that his objective was not to cause physical injury, but was to detain the individual who he thought was James Barrett. However, when attempting to stop and detain this individual, the individual made movements and actions that he was going to run or fight. The proof will show, I anticipate, that shortly after this interaction, that Mr. Pate admits to tussling or fighting with the police. You'll see during this interaction that Officer McAvoy and Officer Sipple take the individual to the ground, causing his head to hit the pavement. During this time, the individual kept reaching for his waistband, reaching towards his waistband, which you'll learn that based on the officer's training and experience is indicative of that individual having potentially a weapon. You'll hear testimony that Officer Sipple does in fact use defensive techniques referred to as distractionary jabs. I don't believe you'll hear any proof that those jabs caused Mr. Pate the physical injury that's being alleged. You'll hear testimony about the officer's training and experience that when in this type of situation, and when confronted with an individual who's actively resisting them, and based on individuals, and you'll see this, and the proof will show, that as this interaction is going on, a number of other individuals unrelated to this are starting to gather around this interaction. You'll learn that based on the training and experience, officers became concerned for their safety as well as others in the community, and that based on the prolonged struggle and the inability of these two officers to handcuff this individual, that a decision was made to tase Mr. Pate. The objective was to gain control of the situation, not to cause physical injury. We're here, and at the end of the day, Officer Sipple made an objectively reasonable mistake. We'd ask the court, upon hearing all the evidence and lack of evidence, to return a verdict of not guilty. Thank you.
All right. I had indicated at this point that the media, if they wished, could relocate, in a sense, and set themselves